All right, I see that we're live on Facebook. I guess, do we want to get started?
Yeah. 1 second. Welcome everyone to an official event of the 9th Annual MSU Science Festival. Today I'm joined by Alex from the MSU College of Law, and we're going to be talking about STEM projects and protecting your intellectual property and legal rights. So hi, Alex.
Hi, nice to be here. Thank you all for having me. I'm going to talk mainly about, I guess I'll wait till I get into the roadmap for my presentation. I'm going to share my screen. All right, can you see this? Yep, okay. All right. As she said, my name is Alex Behrens. I am a third-year law student, and I formerly was a student clinician for the Intellectual Property and Entrepreneurship Clinic at the MSU College of Law. This is being brought to you by the clinic and also by the Center for Law, Technology, and Innovation. Professor Dennis Kennedy of that association helped set this up. And so I'm going to jump right into it. This is a basic roadmap of what I'm going to go through for today. First thing I want to talk about is the purpose of intellectual property. And so this is just why does the US have intellectual property, the US and the rest of the world at this point. Second thing is going to be, what are the benefits to you of having intellectual property? The third thing is going to be a simple idea of how can you transfer intellectual property? This is going to stem from transferring intellectual property being one of the major benefits. And then the final part is going to just go over the basic types of intellectual property. And with that, I'm going to go a little bit into the ideas of how do you get these types of property? How do you, how can you exploit them? What are some of the ideas there? And how can you protect them? I think is one of the main points of all of this. And so to start off with, the purpose of intellectual property comes from Article 1, Section 8, Clause 8 of the US Constitution, that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The main point that we see here is, why is it here? To promote the progress of science and the useful arts. And this is mainly talking about copyrights and patents. I guess as a fun fact at the time, copyrights, which are generally in things more like art, were actually considered to be science, while the useful arts were considered the more technical arts like patents, and this covered things like inventions. All right, that's why the government wants to have intellectual property, and that's why they give people rights. But why should individuals, and all of you, care about having intellectual property rights? What can they do for you? The first major benefit is the right to exclude others from using your creation for the duration of the IP. And what this means is that other people are no longer allowed to use the things that you invent or create. Invent is generally used specifically for patents, so I'm going to try to stick to creation. The second major benefit is that by having a right, you gain the ability to sell or lease that right to others through assignments or licenses. This can, one, be a lot of money, and two, it can give people the ability to use intellectual property that they might not otherwise have. The main example of this is the idea that some products, especially if we're talking about things like pharmaceuticals, can cost tens of millions or hundreds of millions or even billions of dollars to go from I had a cool invention or discovery to I'm selling people a product in the market. And because of the massive costs involved with getting into that, a lot of people just can't afford to use the useful things they invent. And so by being able to assign or license these their products, all of a sudden they're able to make a lot of money without having to put in all of the money, without having to put in the massive investment that would be required otherwise. To talk about license and assignments for a minute, these are more technical terms, and so I just want to go over them. Assignments is basically a sale. This is more of a permanent all or nothing. You're giving someone all of the rights, they own the IP now, and is a pretty formal process. It's got to be written, there's got to be, there has to be certain formalities exchanged. And so it takes some work, and generally you want to have some sort of help with making an agreement like this. A license, on the other hand, is more of giving someone permission to use at least a portion of your rights. And so this could be if you just want for a few years out of an IP right to let somebody try using something, but you can give them a license and they can give you payments every so often or every so many units sold. And by doing so, you will give them a more limited portion. And that's part of where the heavy negotiability comes into it. Another version of that are things like geographic rights, where maybe you have a creation that you only want to use in the United States, but someone else is willing to use it in Mexico or Europe or some other country or continent. You can license to them just the rights to use it in these other places while keeping the rights for yourself in the US. All right, moving into the 4 basic types of intellectual property and kind of some of the ideas about them while explaining what they are as well. The first one is patents, and especially for a lot of more scientific people, this is going to be one of the most important. Patents cover inventions, which are useful things that have a purpose, things like the example I have on the slide is a microwave oven, where someone is going to do something with this, and it is an efficient way of doing it. There are certain requirements for getting a patent: novelty, non-obviousness. I will list some resources later if you want to look specifically into patents. But in general, they just cover all inventions that are useful, things that you will use to do something else. You get a patent by filing with the United States Patent and Trademark Office, or the USPTO for short. This is going to be different from some of the other ones, where this one requires explicitly for you to file in order to get the patent rights, but it also comes with very powerful rights. In particular, 20 years of the right to exclude anyone else from making, selling, or using your invention without your permission. And so by having this right, it gives you a lot of power to control not only who gets to make money off of it by selling it, but also just someone who wants to use it in their own business. They have to pay you for that use, or, well, I guess if you make a deal with them, they have to pay you. If they don't, then they simply can't use it at all. And you will have the benefit of using it in your own business or otherwise. I'm going to talk a little bit about some considerations and some of the tricky things that can come up with intellectual property. And I'm going to do this for all of the major types, just to kind of get an idea of why it would be important to either seek legal aid or put your own effort into securing and protecting your IP, which in this case, the most important thing is to file for a patent. That's if you file and go through the prosecution process, which will take a long time, then you will have patent rights and they will be enforceable. So for patents, the considerations, the first one that I'm going to start off with is inventions made by employees. And so the idea here is that if you're an employer and you hire someone and they're inventing things or doing creative things for you, who owns the final invention? By default, the employee owns it. And that, as an employer, that's a pretty rough thing to end up with, that you've hired someone, they're inventing things, and then at the end, you have to buy essentially or license from them the thing that they hired while they were working for you. And so this is a place where before you start the invention process, their contract should have something that automatically assigns anything they create to you. And so that's a place where pre-planning is going to be a lot better than trying to fix it after it's done. A lot better and a lot cheaper, more importantly. And that's going to be one of the key takeaways from all of this for pretty much everything IP, is that pre-planning is much better than trying to fix it afterwards. The second idea here, similar idea, is joint inventors, is that if there's two people that work to invent something, by default, they own equal shares of that invention. And so while on the one hand, that seems fair, that if two people are going to work on something together, they'll both get a piece of it. But on the other hand, that only applies if they're both putting in equal work. If one person does 10% of the work and the other person does 90, it seems a little unfair that they will both end up owning half of it. And also their rights will be restricted by the other person's half. So if another person owns half of a patent, Well, no, you can no longer assign your patent. You can't sell it anymore because you don't own the whole thing. You can give some versions of licenses, but even then you're still kind of limited in the rights that you're able to give. For a final, more positive note is an idea of something that you can do with a patent that you can do because you own a patent, even if you don't intend to use it yourself or enforce the rights too much, is the idea of cross-licensing, is that you can take and contact other patent owners and hey, if they have a useful technology you want to use in your work or in something that you're researching, you can give them access to your patent and they can do the same for you. And so now, even without necessarily the profit motive, it can still just help work and make deals by owning intellectual property. All right, moving on to the second portion, or the second basic type of intellectual property is copyrights. Copyrights cover works of authorship. Works of authorship include things like movies, books, pictures, sculptures, various types of art. And I think one of the ones that people don't think of are things like advertisements. So if you make an advertisement for a product that you're selling, you have a copyright in that. And if someone was to take it and use it themselves, then you would have rights against them to stop them from using your creation, which would, in this case, would be the advertisement. And so here's a place where having a patented product and then advertising that product, you now have both the patent and you have the copyright. And so you have multiple levels of IP protecting this thing. Unlike patents, which require filing in order to have rights, copyrights exist from the time that the work is put into a physical form or is actually created. There are still significant benefits to filing for a copyright from the United States Copyright Office, and that is something that I would recommend everyone who thinks they have a copyright should do to, one, confirm the date of their rights, and two, to give them rights such as the right to sue in federal courts, the right to actually get money damages from somebody who infringes your rights. Things like this are very important, and even though the rights exist without filing, it's still highly recommended to do so. Copyrights grant the owner currently 70 years plus the life of the author, the right to exclude others from reproducing, making derivatives, distributing copies, performing, or displaying the work. This is a very, very long time, obviously. Copyrights aren't as much of a useful art, and so it's considered a little more free thinking for people who want to think around it without using it. And so people are allowed to have a lot longer time with a copyright. Moving into some of the copyright considerations. One of them, similar to patents, is the idea of what if you have someone working for you who creates a copyright? But opposite to patents, in this case, if an employee makes a copyrighted material in the scope of their employment, then the employer owns it. And so this is a place where if you're dealing with a copyright or a patent, there's going to be very different rules for how many safeguards you need to make sure you have the rights you need to use your creations. A second idea here is joint creations and multiple owners. Once again, you don't want to have people who did very little work, but own half or a large portion of the copyright. This is a place where it's important to kind of settle these things out beforehand, make sure you have a deal to know who owns what and what they should be doing. A final point here is new technology considerations. This is something where a copyright, especially in terms of licenses, there can be issues where if you have a book and you license out the rights to that book, well, does that include an ebook? There was a case, I think, in the circuit courts that said, no, it doesn't, based on the language of that license. And so one of the things to be careful of with copyrights is, are you planning for the future when you make licenses, especially as the person who wants a license for one of these things? The third type of intellectual property is trademarks. These cover brandings and logos. I have the classic example, McDonald's here. People know the golden arches, they know what it means, they know what it stands for. Trademarks actually have a different purpose from the previous two types of intellectual property, and that trademarks are meant to be a form of consumer protection. So people know what they're getting when they buy something. And that changes exactly how it's in, or how some of the rules around it work and some of the things that you need to watch out for with a trademark. One thing that's very different because of that is that the trademarks don't have a set time limit. As long as people are properly maintaining the trademarks, they can have them forever, which properly maintaining generally refers to the idea that you have to renew your trademark early on every 5 years and then later on every 10 years. And then also something that'll come up in the next slide, which I'll just move on to it now, is that trademarks can become generic. And this is something that people need to watch out for if they own a trademark, is that if a trademark is used in a way that doesn't signify the brand, if it stops being associated with the brand, then all of a sudden you don't have that trademark anymore. It's become a generic term. An easy example of this is something people don't know, is that escalators used to be called moving staircases. And originally, Escalator was a company that made moving staircases. However, they apparently did too well at making moving staircases, where everyone started to refer to every moving staircase as an escalator. Over time, they lost their trademark because all of a sudden people weren't referring to escalator brand moving staircases. They were just referring to escalators generically as for every moving staircase, whether it was an escalator brand or not. This is one of the reasons why you will see companies like Google try to put out ad campaigns around the idea of they don't like people saying Google it as a verb because they're worried that they're going to lose the Google trademark. And so they want to show that they're trying to protect it by saying things like perform a search on Google, like making sure that people are referring back to Google. Some other considerations are that if people are trying to transfer a trademark, if you're trying to buy one or sell one or license it, then it's important to make sure that because trademarks are a source of consumer protection, there needs to be some assurance of quality where you can't just license a trademark to someone else and then they drop quality massively, because then it stops serving as consumer protection. And so the person who was to license in that case would probably lose their trademark because it's no longer that seal of quality. And that goes into these two blunders. Naked licensing is when someone licenses a trademark without maintaining quality at all. And you can lose the trademark from that. Another option is accidental franchising. And this is the opposite, where someone tries to license a trademark and they are too controlling and it starts to look more like a franchise, which that's similar to if someone opens their own McDonald's store, they have to get a franchise from the main McDonald's store. And that ends up being subject to additional tax laws, antitrust laws, and a whole host of other laws that people generally don't want to deal with if they can get around it. The final type of intellectual property I'll talk about is trade secrets. Trade secrets are a little different from the rest in that they are secrets. The rest of them are disclosed to the public. That's part of the benefit of them. That's part of the reason we give benefits for them. Trade secrets are things like the example here is the recipe for Coca-Cola is still a trade secret. The main point of this is if people have a secret recipe or some sort of business practice that they use that no one else knows about, then they are allowed to keep it a secret and they will get some limited rights in it. The main rights from this are things like the enforcement of non-disclosure agreements and NDAs, non-disclosure agreements and non-compete agreements. And this is just to prevent something like an employee works at your company, learns all of your secrets, leaves, starts their own company with all of their secrets in violation of some contract. And that's the main benefit of them, is trying to keep things like that secret. It's also why these aren't filed anywhere. There's nowhere to do that. And they're created by instituting those safeguards, by having people sign NDAs, by having non-compete agreements for employees who leave, things like this. One of the big issues with trade secrets is the idea that people have to choose generally between having a trade secret and a patent, and the idea that you can get a patent for 20 years, or you can take the risk on getting a trade secret. And the risks, and these are the risks right here, these considerations. In particular, that once a trade secret is out, it's generally just out. There's no bringing it back in. It's been discovered and it's out in the public. You might be able to punish the people who, if they wrongfully disclose that secret, you might be able to go after them legally or some other way. But in general, the secret is out now and you can't keep it anymore. And the second major drawback is that there's no protection against independent creation. If someone just happens upon your secret recipe, you have no protection against that. You only have protection against someone who wrongfully discloses your secret. All right, that was a lot of information. And if anybody has any questions, I'll be happy to ask. Here are some further resources. The clinic website and the Center for Law, Technology, and Innovation are going to have multiple presentations similar to this one, but a little more pointed towards particular topics or types of intellectual property. They aren't up yet, but we're hoping to have that sometime soon. The United States Patent and Trade Office has videos on patents and trademarks that are very good. They also have a list of opportunities for nonprofit legal aid, including law clinics like our own and pro bono attorneys who would be willing to work for free on certain pieces of it. And the Copyright Office website has information on copyrights. These are all the links, and you can find them by Googling them as well. Key takeaways are just that intellectual property are valuable assets that should be protected with the proper steps. And two, that the best way to deal with IP problems is to plan for them before they become problems. Finally, here is the IP Clinic, MSU IP Clinic contact information. One thing with the IP Clinic that I want to stress is that they only operate in the fall. And so right now, it might be better to look towards the USPTO list of other clinics and or pro bono attorneys. But come fall, they will be back in session and they will be able to help with some of these IP issues. All right, that's all I have. If anybody has any questions, I'd be happy to answer.
Thank you. I have a question. So can you tell us about what the most interesting case like that you've heard of or that you've been a part of?
Been a part of, I've operated in pretty limited cases just because I'm a third year law student still. So most of my work has been with the clinic. And that's been, I guess trying to think of how much detail I want to go into. I have to keep something secret, but there was a client who was working on music licensing, and she was particularly wanting to work with some big artists, some small artists, and kind of work with them and try to set up a company where she would be licensing from these various artists and giving them the opportunity to anonymously contribute while trying to license to movies and TV and trying to do like synchronization licenses is what they're called. And so the idea of like trying to make music for various like television for various types of media. And this was it was legally complicated in some ways, the types of things that you need to do and the various licenses you need to get. So from a legal standpoint, it was kind of fun. And just from the idea of, oh, this is stuff where she wants to end up like, working in Hollywood or places like this, like it was kind of fun as well, I think. Other than that, some patent stuff that's I don't know how much I can reveal there, just because especially if people haven't filed for their patents yet, then I can't say what their inventions were because they're still keeping that while they're waiting to file. But yeah, as part of the clinic, we got to work on a lot of interesting stuff. I think some of it, because the clinic has limited time scope, they're not able to help with everything, where they operate only in the fall and for 3 or 4 months, where like a patent prosecution can take filing for a patent and going through that whole process can take a year or more pretty easily. And so we're not going to be able to help with that whole process, but it was cool to be able to look at people's inventions, help them look for like, hey, were there prior inventions that are too similar to yours? Or do we think you're good to go? Like, and that was a fun process to kind of look at what people were doing and what they were interested in.
Yeah. If anyone has any questions, feel free to type them in the Q&A. I guess another question I have for you is, what got you interested in like this type of law?
For me, I was originally just kind of, part of it was just luck in that I had taken classes that kind of fit into my schedule, and I realized I happened to take patent law and I happened to take copyright law, and it's like, oh, when I look at the prerequisites for the IP clinic, I hit them all by accident. Like, this sounds like a cool idea. And so that was one half of it, was it just lined up really well. The other half was I originally wanted to go in for some sort of commercial, some sort of business law, but I didn't know necessarily if I wanted to work with extremely large companies and that kind of like full-time corporate law. I didn't know if I wanted to go there, but I didn't know if there really was a space to work with like small businesses, entrepreneurs, creative people. And I kind of discovered that IP is a place where you can do that, where even if someone is a small business, if they're going to be making, creative projects like music, songs, movies, that kind of stuff. Movies might be a little too big for a single person, but some other creative projects, or if they're going to be trying to invent things and then license them out to bigger companies, then there is a lot of room for them to have a cool and starting business. Trademarks especially is also a great place for small businesses, where I worked on multiple of those, like searching for those and looking around for them. So I think, yeah, I think it kind of, it happened to align with what I had already done. And then I realized that it kind of aligned with what I wanted too. And so it ended up working out pretty well for me.
Yeah.
I see a question also from Larry Hoff. How do you counsel clients on whether their invention is patentable? For some things it's a little easier, like you wrote a few here: patentable subject matter, non-obviousness. For patentable subject matter, that's a little clearer just legally. Like some of that will be just looking at prior cases and seeing, oh, what have we seen? What have the courts looked at and said, this is too close to patentable subject matter, what is not? And so just kind of looking at what's happened previously. And a lot of that will come from people challenging patents for being issued improperly or for should have not been issued. You can also look at, I believe the USPTO has, I think it's a free service as far as I know, where you can look through old patents. Not only can you search them, but you can also kind of look through the process of prosecution and like, oh, why, like the USPTO denied it here. Why? Well, they said they thought it wasn't patentable subject matter. So you can look through some of that stuff. Non-obviousness is that's a little more common, and that'll come in, and that generally just goes through a patent search, and that's just trying to search for things that are close. Well, one, doing, like I just mentioned, the idea of searching through case law, and that's a time-consuming process that doesn't always lead to 100% results, but it kind of needs to be done. And then also just searching, one, you can search even usual searches like Google Patents, things like that, and then taking that to the USPTO website. That's a good way that we learned to do it, was to kind of look things up in something like Google Patents and find a patent that's somewhat similar to yours, take that to the USPTO website, and then search through what parts of this, like how is this classified and what parts of it do they think are problematic or what parts got passed, and then kind of search based on those parts to find it. At the end of the day, I don't think most places won't give people a 100% or not on whether or not a invention is patentable. That's just hard to know before it's gone through the process. But in general, you can be pretty sure. You can, it's very easy to rule things out. I would say that. It's very easy to say, hey, this is a really cool invention, but somebody's already thought of it. So it's really easy on that end. It's hard to say, yes, you will be able to get your patent. Like that's a tougher one because that does have to go through the process. Yeah, I hope that's a good enough answer. It's tough, and it's part of the reason why we get paid to do it, because there's a lot of searching and a lot of work to be done and a lot of calls to be made on, is this close enough and how do I argue that it's not? I don't mind waiting a few minutes, or if you want to call it, if there's no more questions.
Yeah. If no one has any other questions, yeah. Thank you, Alex, for being with us tonight. It was really interesting.
Yeah.
And everyone else, be sure to check out the Science Festival website, sciencefestival.msu.edu, for more events coming up throughout the month of April. Thank you.
Yep. Thank you for having me. It's been fun. I hope it was helpful for people.